Hello and welcome to episode 77 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Joanna Baron, the CCF's executive director. Christine is away today. And in today's episode, I'll tell you about some of the constitutional questions that people are raising about and Josh just told me that this is the preferred parlance, Prime Minister designate or Prime Minister elect will be our Prime Minister tomorrow around 11 a.m., March 14th, Mark Carney.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to update you on the outcome of a lawsuit in Northwestern Ontario, where a court has awarded $380,000 to some drag queens and drag kings and another organization who were accused of being, quote, groomers. It's a really interesting lawsuit. So this was actually two lawsuits in the beginning, but one decision because they had similar facts. And the first lawsuit was launched by the Rainbow Alliance Dryden, which is an LGBT group, a nonprofit, and someone named Caitlin Hartlin, who identifies as non-binary and who performs as a drag queen named Jack Doff. And I can say that on the podcast because it's in a legal judgment, Joanna. The second was launched by someone named Felicia Crichton, a Thunder Bay person who is described in the decision as a pansexual, although I'm not really sure why we need to know that. And another performer who goes by the drag name Ms. Molly Poppins, which apparently is an homage to Molly Weasley from Harry Potter and not necessarily a reference to the club drug MDMA,
Funny because
aka
in your notes
Molly.
you have poopins, which I like better.
I don't think that's in the legal decision. I think that's just a typo. Anyway, and the other person involved is someone named Jean-Marcel Forget, who identifies as Two-Spirit and performs by the drag name Lady Fantasia La Premiere. Okay, so what happened here, according to the decision, is that the defendant, Brian Webster, ran this Facebook page in Thunder Bay where he defamed the defendants. Back in 2022, the Rainbow Alliance had planned drag events in Dryden, which is a little town of a population of 7,388 people. And this included a drag brunch, adult drag events, and also drag story time for all ages. And Hartlin, aka Jack Doff, was scheduled to perform, but not for kids, let's be clear. And posters went up with Hartlin's photo and name. This was followed by a CBC story by someone named John Thompson about how someone had called the police to report this drag brunch as a supposed attempt to groom children. And not long after that, Hartlin discovered that this page, which was run by Webster, called Real Thunder Bay Courthouse Inside Edition, had been posting a poster with her name and face on it and an unrelated photo of a child being held by a drag performer. And the text of the post said that taxpayer-funded CBC reporter John Thompson has an agenda to promote. Ask yourself why these people need to perform for children. Groomers, that's the agenda. Just look at the face of one child in the photo. Tells you all you need to know, defund CBC. Then came another post which targeted the other applicants here, which is Molly Poppins and Lady Fantasia. And this included a poster advertising their drag queen story hour at the Thunder Bay Public Library. So Mr. Webster published a promotional image of this upcoming drag queen story hour with this following text, which the court found to be defamatory. And it said, City of Thunder Bay promoting deviant behavior to children. Thunder Bay City Council, so far in left field, they're promoting drag queen story time to young children in our city. Apparently, our city council is completely unaware of local drag queens who have been criminally charged with child pornography. Do your children a favor and have them avoid the library in Westfort today. Don't ask yourself why drag queens need an audience of children. The answer might involve the word grooming, and then it goes on and on. Then it says, in fact, a senior employee was just sentenced to 20 months in jail for making child pornography and uploading it through the TB Lazy Watch internet. They refuse to tell the public about it. Ask yourself why they're trying to hide this. Read more on local drag queen and link below. Read more on TB Lazy Watch child porn employee below. Now, this is very important, Joanna. As the judge notes, the links to the online articles identified individuals who had been charged with child pornography offenses, but they were not, and I repeat, not in any way related to the actual plaintiffs here or the actual events that were being advertised. So they were tied together by this person, but they were completely unrelated. And it's important to note none of the people in this, none of these applicants were charged with anything criminally at any point, and nor is there, any evidence that they were interested in children. That just appears to be fiction. And this is a defamation case, and it's quite easy to establish defamation as long as the words would tend to lower the plaintiff's reputation in the eyes of a reasonable person. As long as the words referred to the plaintiff and as long as they were published, then defamation's been established, and then you turn to defenses. And usually the defenses are either truth or they're fair comment or they're something like responsible communication in the public interest, which is what we do on this podcast. But obviously there's no truth to these horrible defamatory statements. Of course, whether or not the truth or fair comment defenses could be established here really did turn on the words groomers and grooming. And the judge noted at paragraph 61 that, quote, at its core, the issue in both actions is whether the terms groomers or grooming are defamatory. The plaintiffs, she wrote, contend that these terms are a slur that implies that the plaintiffs influence and manipulate children for the purposes of sexual exploitation. In other words, the plaintiffs are pedophiles. The defendant, on the other hand, argued that drag performers were grooming children to, quote, live queerly and not for sexual exploitation. And he put forward a definition of grooming that says it's just the, quote, practice of preparing or training someone for a particular purpose or activity. And the judge didn't buy this at all because, Webster had attached that story about possession of child pornography to the posts. Again, stories about someone not linked to these people at all. And the judge found that groomer is a slur, that it's widely used in hate rhetoric to target LGBTQ plus communities, especially drag performers and performances. And so this was obviously defamatory, and Webster had to try to make out a defense. And he tried for the fair comment defense, which requires showing that one is commenting on a matter of public interest, that the comment is recognizable as comment as opposed to fact, that a person could honestly express that opinion on the proved facts, and that the comment wasn't actuated by malice. And, this obviously wasn't a fact. None of these people had been charged with criminal conduct. And so you go through the analysis and it's not going to be made out as a defense. And the court awarded $75,000 to each person in general damages, plus $20,000 more in aggravated damages for each person, plus costs. So what we're looking at is probably upwards of $500,000 total that this man now has to pay. And I've got to say, I do have some mixed feelings about this decision. On the one hand, I feel badly for these drag performers who were defamed. And I think that, implying people are pedophiles causes harm to them. On the other hand, the decision is being spun by a lot of people to suggest that you can't even use the word groomer or groomers at all to discuss things like Drag Queen Story Hour or all ages drag events. And if that's the case, I think that's really chilling for freedom of speech. And, we should be allowed in a free society to use these kinds of words in some contexts. And for example, I've had discussions with friends who have used this word, and I don't agree with them about their conclusions on it, but I can sort of understand where they're coming from. And I think it's important to have these discussions so that we can figure out who's right and who's wrong about these types of things. So, the friends I've talked to, they'll say, look at all these stories about gay teachers or priests or scout leaders who are molesting children. And they'll point out that, drag is inherently sexualized. It's basically, a burlesque performance by a person dressed up as the opposite sex, although obviously they tend to tone it down when they're doing it in front of children. And so they say, this is clearly grooming, this in the sense of grooming children for some adult sexual activity. But my response to that is like go onto CanLii and look at who actually sexually abuses minors, and you can see the vast majority of them are not in these contexts like the priest or whatever. That's just the stereotype. The vast majority are straight males molesting females, and often in its family. It's really disgusting to think about, but that's the reality. I think their better argument is the latter one, which is, they say, well, this is a form of adult entertainment originally, and so why do they want to now transpose this and modify it for kids? And their conclusion is that it's grooming. I think that's completely wrong. I think that what they're really doing here in a lot of cases is just sort of trying to own the conservatives and trigger the conservatives, the social conservatives, by doing something that's considered like really aggressively woke, holding like a drag performance in a library. And so I don't think it's about grooming. I think it's about triggering people. And I think that stories like this show that it's really working. So Joanna, I don't know what you think about this. Like, it's a really huge award. It's gonna, ruin this guy's life. But at the same time, he was found to have defamed them. Like, what are your thoughts here?
Yeah, it's a really tough case, but I think basically there is a bright line that can be drawn, and I don't the amount of the award is something different. You could argue that it's excessive, and perhaps he can appeal it, but we shouldn't create a false equivalence between criticizing drag events, protesting drag events, which we know a lot about from our Calgary City Hall case, because although in that case, the bylaw, of course, applied much, much more widely, and we may have had a different disposition if it was just, targeted towards Drag Queen Story Hour. It had a much bigger catchment. But there's a difference between criticizing Drag Queen Story Hour, which any individual is free to do within the boundaries of peaceful protests at any place, at any time, in public places. There's a difference between that and accusing specific individuals of pedophilia. And so here it sounds like to me, having just heard about this case from how you summarized it, the court was ruling on specific defamatory statements that linked specific individuals to child pornography charges. And I think the proof in the pudding is that this guy Webster deliberately connected these performers to child pornography charges through these bogus links and explicit text. And that goes beyond just fair comment and expressing an opinion. So I don't think that this is somewhere where we should get into a panic about free speech because you don't have the right to criticize Drag Queen Story Hour. You do, but you don't have the right to accuse people falsely of being pedophiles. Sound
I say
reasonable?
that's fair comment.
Yeah. Okay, should we move on and talk about our soon-to-be, in about 24 hours, soon-to-be Prime Minister?
Let's
So,
do it. Yep.
yeah, so
I
Mark Carney, the man of the hour, apparently. I was just listening this morning's daily podcast is all about him. And by the way, I just got back from a little March break in Texas. Yes, I was in the belly of the beast, but I assure you that I made these travel plans before the current trade war. And I did go to a South by Southwest sort of side event earlier in the week, and it was sort of right of center tech crowd. And some AI entrepreneur, when he found out I was from Canada, immediately asked when we were just going to give up and accept that our destiny was to become the 51st state. I gave him a mouthful. I said, absolutely never. You don't understand Canada, you arrogant tech bro. But anyways, meanwhile, back at the ranch, Mark Carney is going to be sworn in tomorrow as our 24th prime minister. But there are significant constitutional questions that many people in the legal community are raising. So some were canvassed by my former boss, Howard Anglin in the Hub, who has the piece this week in the Hub, where he talks about how, unlike previous prime ministers, Carney has no parliamentary experience. He was selected through an online poll of Liberal Party members, not through an election. So there's some depreciated democratic legitimacy there. And Howard argues that he's beginning his term on what he calls thin constitutional ice, without the confidence of the House and facing opposition from three parties. So when the government's legitimacy is in doubt, as here, Anglin argues that the government's powers should be limited by the caretaker convention. under this convention, government activities should be restricted to matters that are routine, non-controversial, urgent, reversible, or agreed to by opposition parties. The convention prohibits using government resources for partisan purposes and would require that he defer appointments, policy decisions, and new spending. Howard also argues that if Mark Carney attempts to issue orders in council that would violate this convention, the Governor General should delay signing them. It's funny how a lot of stuff in Canadian politics tends to turn on what the Governor General should and should not consent to do. He does concede that there are exceptions, like for responding to urgent matters, such as, for example, responding to American tariff threats. But he concludes that Trudeau's decision to prorogue Parliament rather than call an election has already stretched our Constitution, and Mark Carney shouldn't be allowed to further strain it. So we'll talk about what we think about that in a moment. But I think even juicier, I've become aware through private conversations and conversations on sort of Law X that a lot of people are chattering about whether it would be worthwhile for public interest litigation groups such as the CCF, although for reasons that will become clear in a moment, we are not going to do this, should consider bringing an application in court for a writ to prevent the Governor General from swearing in Carney. And the suggestion is that appointing a non-MP, because of course Mark Carney is not a sitting member of Parliament, he has not won an election in a riding, also not a senator, violates constitutional unwritten principles of democracy and responsible government. And these people suggest that constitutional jurisprudence has evolved enough since the last time this happened, the last time we had a non-MP prime minister, John Turner, in 1984, to justify a legal challenge. Now, in my opinion, there are many reasons to be skeptical of this proposition. First, cabinet ministers, and this was pointed out by a friend, cabinet ministers don't need to be MPs, and the prime minister is considered to be first among equals in cabinet. And further, the prime minister must obtain and maintain confidence in the House in a Westminster system. And MPs have a clear, established, workable mechanism to remove the prime minister or trigger a non-confidence vote. And the Governor General's primary constitutional role is ensuring that the government holds House confidence. And of course, she dissolves government if the PM loses confidence of the House. And so perhaps constitutional principles have evolved since 1984, but the courts remain and rightfully remain reluctant to convert unwritten constitutional principles, vague unwritten principles, into justiciable legal principles that can be used to do something like constrain the power of the Governor General in a direction that has never been established before. The Supreme Court has distinguished between conventions and enforceable legal rules, and creating a judicial requirement for the Prime Minister to hold a parliamentary seat would represent a new intrusion into the internal affairs of Parliament. These are areas that are traditionally beyond judicial reach, and for good reason. So think down the line a little bit. If we were to get a court order that would constrain the discretion of the Governor General in this way, blocking Carney would force the GG to either choose another Liberal to be leader or negotiate with Trudeau about staying on or calling an election. So the Governor General would clearly be in the pit, in the political fray, which there are good reasons why we want her to be elevated above the fray as the representative of the King. And in terms of democracy, I think it's more democratic to let the governing party choose its leader and let the House and ultimately the electorate decide what happens next. If a court ruled that only sitting MPs could become prime minister, this would empower the Governor General to reject party leadership choices, and there's no mechanism to enforce that rule without expanding Governor General discretion. But there's no question that this raises a tension between the democratic principle of having an elected prime minister, because we can all agree that Mark Carney is currently not democratically elected. We'll see what happens once he actually has to form government. and Westminster parliamentary conventions. So that was a bit of a mouthful. Josh, I know I raised this question with you because somebody asked me about if the CCF was interested in commencing something like that when I was on vacation, and you just said you agreed with my assessment, but having heard a bit more of my reasoning, do you agree?
Oh yeah, I certainly agree. I think it's crazy. I think we need to leave the power in the hands of the people where it belongs. I think there are much bigger issues with this weird prorogation period, so that Trudeau can find his replacement, which has now been found, that are more concerning. They're probably also just convention related concerns, and so not really enforceable by the court. But like, for example, just this outgoing government, so not even talking about Carney when he becomes prime minister tomorrow, unless this lawsuit is launched and succeeds.
They can
Um,
do it.
there's 23 hours left. We're recording this on Thursday. The big problems I see are, Parliament is it's the people's representative, right? The executive that's running things right now is not, even though the cabinet's drawn from MPs, and they should get a say on things like spending, major new spending. And this government, I don't think people have even noticed. There's been a whirlwind of spending in the past few weeks, including signing contracts in the tens of billions to build new ships and things like that in Quebec City, in New Brunswick, I think also in Vancouver, if I'm not mistaken. And a huge election issue right now is what to do about defense and how to procure things faster that we may need to defend ourselves from the U.S., which is quite hostile right now. And are we going to buy things in France? Are we going to buy things in Sweden? Are we going to buy things from Korea? And apparently the government's just signed contracts with all of their friends in New Brunswick, like the Irvings, and in Quebec City, which is always a very contested area between the conservatives and liberals. So that really bothers me that they're doing this in their sort of dying days when they technically still have confidence, the confidence of the House. So I guess technically they can do that, and maybe the money is already accounted for in some way, but it just seems illegitimate. And they're also signing these huge agreements with Indigenous people to settle land claims, and doing that at the very last minute seems a little bit shady to me. Yeah, and there's example after example of them just sort of rushing money out the door last minute. There's hundreds of millions I saw the other day are being devoted to Bangladesh. It's some gender-based anti-climate change program. I feel like the vast majority of Canadians wouldn't support that spending, and yet they just signed that and posted it the other day. So whatever the
Made in
actual.
Canada Doge, that is some USAID hijinks right there. So I would say we both agree Anglin is right. They should think of themselves as a caretaker government, and they clearly
Yes.
they're not.
Yes, and my point is just not just Carney, but also the outgoing Liberals should
Yeah.
have been acting that way, and they didn't. But I guess they're gone as of tomorrow, and it's a new cabinet. So anyway, enough about that. Let's talk about our bad legal takes.
Should we take a break first?
Oh yeah, break first. Okay, so maybe I'll go first then, Joanna. So my bad legal take goes to Anthony Koch, who's a conservative consultant whose tweets I generally like, and I've met Anthony. I think he's a cool guy. I like him. No personal beef, but this tweet was really just very wrong. It misconstrued the Supreme Court's decision last week that struck down Ontario's spending limits on third-party advertisers, and he called this decision, quote, Canada's Citizens United. And do I ever wish that were true? It's actually basically the opposite. For those who don't know, Citizens United is like a famous US Supreme Court decision, very controversial, from 2010, that found that political spending is protected speech under the First Amendment. And so the government can't restrict that based on the speaker's corporate identity. In other words, spending limits are not allowed and disclosure laws are fine, but corporations also have a right to speak. They're groups of people at the end of the day, and political spending is free speech. It's pretty obvious to me. A lot of people from sort of the left to the right don't like Citizens United. They say there's too much money in politics. But my counter to that is the reality that there's no real way to regulate what someone spends versus someone else without interfering with speech, because that's the way we express ourselves. And once you start making rules, you end up with like winners and losers in the political advertising regulation game. And we had our Canada's Citizens United back in 2004, a case called Harper in Canada, where Stephen Harper, who was then president of the conservative third-party group National Citizens Coalition, challenged the third-party spending limits that were in place at the time, arguing the same thing, that this spending is freedom of expression. It's obviously protected. But the Supreme Court found that these limits were fine, and that led to this sort of absolute hash of a decision last week. I won't go too deeply into it, but basically Working Families is this coalition of interest groups, including things like unions, and they had basically advertised against the PCs in Ontario for many, many years. And Doug Ford wanted to sort of get his revenge, I would assume, by banning third parties like Working Families from spending more than $600,000 in the 12 months before elections, which was a very long time. Political parties were allowed to spend $1 million. So there was like sort of a disadvantage if you were a political party versus a union group doing third-party advertising. So Working Families challenged this. They won at the lower court level. Doug Ford brought this law back, using the notwithstanding clause, which should have been the end of the story, because that says that the law is going to stand notwithstanding the freedom of expression issue. But instead, these groups got creative and they made an argument based on Section 3 of the Charter, which says every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly, and to be qualified for membership therein. So basically, it says you have a right to vote. It says you can be qualified for membership in the House or the Assembly. It doesn't say anything about third-party advertising limits or freedom of speech, but the court accepted that this has a component of freedom of expression, even though I would argue it obviously does not. And this goes back to Harper. They were sort of somewhat bound by that. In any event, this is Canada, not Canada's Citizens United, very much the opposite. The judges found that politicians can limit spending by various groups as long as there's no, quote, disproportionality in the eyes of the court. And in this case, they found there was. And that means the courts have basically transferred to themselves the power to decide which third parties get to speak, which politicians get to speak, to what degree, how much they can spend. And I think that's very bad. So, bad legal take from Anthony. You got that one wrong. Bad legal take from the courts, I would say too. So bad legal take, everyone. And that's all I have to say about that. Joanna, let's hear yours.
So my bad legal take takes us out to Newfoundland, where 3 Memorial University students who had trespassing charges against them dismissed after being arrested during pro-Palestine protests and encampments last summer have announced that they're planning to file a Newfoundland Supreme Court judicial review and charter challenge. They are arguing that the university violated their right to free expression. They occupied the Memorial University MUN's administration's building's lobby beginning in June. And police removed them. And more than 8 months later, the Crown has decided it's no longer in the public interest to pursue the charges of trespassing, although they state that this isn't due to a lack of evidence, and prosecutors do this all the time. I would not second guess their wisdom. Perhaps cooler heads have prevailed. But the students are arguing, or rather their lawyer, Kyle Reese, is arguing that MUN is a state actor, and therefore the Charter of Rights and Freedoms applies to them, and just having the charges not pursued isn't good enough. They also want some type of charter damages. Now, This claim is a bad legal take in my submission this week. First of all, deja vu to last summer's, was it last summer? Yeah, I think it was last summer's U of T encampment decision, which at the time, by the way, Memorial University, once the U of T decision came out, they said this same reasoning, which found that protesters were not entitled to occupy a space to the exclusion of everyone else, that trespassing law applied, et cetera. Basically, that they didn't have a right to indefinitely take over parts of the campus, popular central parts of the campus. At the time, MUN put out a statement saying, we believe that this same reasoning applies. We are going to enforce against these students and remove them from their occupation. And at the time, there was chatter from people like our friend Heidi Matthews that it completely didn't apply and there were completely different considerations. But yeah, it clearly does apply. It's clearly a very similar situation with very similar reasoning. And courts have consistently recognized, even before the encampment decision, the U of T encampment decision, that freedom of expression does not include the right to indefinitely occupy private or institutional property. The Supreme Court has distinguished between content of expression, which is protected, and location or method, which can be regulated. These students were free to express pro-Palestinian views and even anti-Semitic views, but they don't have an unlimited right to occupy administrative buildings at all hours, after hours, as part of that expression. And finally, although some university actions, of course, can be subject to charter scrutiny, the courts have held that not all university activities fall under the scope of the charter. So administrative functions like building security, hygiene concerns, access policies often fall outside of charter jurisdiction. So I don't think this is a good lawsuit to pursue. Take the win. The Crown has dropped the charges, and this case is a bad legal take.
All right, that's the show. As usual, if you haven't already, please go and rate us, review us, and subscribe. You can support our work by subscribing to our YouTube channel, by following us on X, or by visiting our website and signing up for the Freedom Update newsletter if you haven't already. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.